Thank you very much for being here with us this afternoon in this conference in the master class program organized by WIPO and Instituto Derecho de Autor. We are very grateful for having you here today, and I would like to ask you a few questions with regard your work as a mediator on the private copying process held within the European Commission. The first question is very basic. Can you give us your general impression of the mediation process that you led last year? Do you think that after that mediation, the positions of the different stakeholders have moved a little bit? There has been an improvement, in your opinion? You propose also in your recommendations that maybe the next step should be a consultation within the member states. In which way, in general, do you think a consultation could be helpful? And what are the steps that you think that should be the next ones to be undertaken in this field?
Thank you. First of all, it is a great pleasure to be here in the Instituto de Autor in this master class on a subject that has been pending in the European agenda for quite several years. And I cannot say that the positions of the stakeholders have become closer after the mediation, but probably that's the purpose of a mediation. It's to have a mediator to blame. So in that respect, I think that the positions of the stakeholders have been rather entrenched. And to a certain extent, I failed to persuade the stakeholders to take ownership of the process, because there can be only progress if at a given moment the key stakeholders are prepared to compromise, are prepared to move. And in fact, I think that the departing positions were very far apart. And at least if there is something positive in the mediation, I should find something positive in the mediation, is that we have tried to establish the perimeter of the questions that will have to be addressed in order to guarantee the compatibility between the private copy levy system and the functioning of the internal market. In that respect, I hope that the positions of the stakeholders have become more clear. I've made some recommendations that are, of course, controversial. I expect that not only in the reaction to the recommendations, but in the follow-up of the recommendations, the key stakeholders will come forward with their own proposals and with their own alternatives. And definitely at the end of the line, the member states will have a key role to play. And that's why one of my suggestions to the Commission was to have a follow-up in direct consultations with the member states. At the current moment, I can say that the Commission has launched a public consultation on the digital economy as a whole, on the copyright in the digital world, that was launched on the basis of a communication from the European Commission of December 2012. And this consultation will come to an end in a few weeks, in the beginning of February. And then the Commission will have to take stake of what has been contributed to the consultation. And in parallel, as far as I know, the Commission is also developing a bilateral dialogue with the member states. So hopefully in the spring, the Commission will come forward with their own proposals about the way to proceed.
Okay, so we can say there has been a positive...
At least there has been some move.
Exactly, okay. You mentioned it already, that the European Parliament is also working in this moment on the private copying issue. There is a draft text agreed between some political parties. I'm afraid that not all of them. Are you following this debate in the European Parliament? Do you think that this work will be a good complement to your mediation process and the other initiatives that you mentioned?
Yes, definitely. I think that according to the functioning of the European Union, the right of initiative comes from the Commission, but the Parliament is a key stakeholder, because at the end of the day, all legislative proposals will have to be adopted both by the Council of Ministers and the European Parliament. This is our own initiative report of the European Parliament, so it's a contribution of the European Parliament to the overall debate. And I don't know when it will be concluded. There is a compromise text that is still going on in the negotiations between the different political groups. There are very different views also in the Parliament. It's not exclusive of the stakeholders and of the member states to have very different approaches to the private copy levy system, and therefore I'm very much looking forward to the conclusion of this process in the Parliament.
Okay, and focusing on your recommendations, with regard recommendation number one, in which you say that there should be necessary to clarify that copies that are made by end users for private purposes in the context of a service that has been licensed by right holders do not cause any harm that will require additional remuneration in the form of private copying levies. Is probably the recommendation that has been most criticized by right holders, because in their opinion, such a proposal will deprive consumers of their ability of making private copies legally. It will involve the reintroduction of technical protection measures that had been very much rejected by users, and also it will require to renegotiate the remuneration for private copying within the purchase price of the digital content, which in this moment, with the unbalanced situation that right holders have in front of powerful digital content users, will be very hard. I'm sure you have thought a lot about this recommendation and all of them. What is your opinion about the worries from the right holders and in this respect?
Well, you have raised quite a lot of questions. Let me try to address all of them. First and foremost, there is something I would like to clarify. I believe that the reactions of the right holders to recommendation number one are based on what I consider an artificially broad interpretation of what the recommendation says. The recommendation has a very specific target. It's about online environment and only services on demand. So the scope of that recommendation is to address the challenge of new business models that are emerging. It does not interfere with what we could consider classic private copy levies on a CD or on a book. It is excluded from the scope of what I have just mentioned. Having said that, maybe I need to clarify that my perception is that we are experiencing a shift of paradigm, in the sense that all the system has been built traditionally on the concept of ownership of content, which means that the devices that are levied are devices that aim to store content. And the new business models that are being developed in the online environment are much more focused on access to content. You do not own the content, you just have a right to access. And definitely with the spread of the cloud computing, this kind of services will become each time more and more important. Having said that, I don't believe that private copy levies will disappear. At least they will not disappear overnight. And I do believe that there is a need to improve the classical private copy levy system as it stands today. But in parallel to that, I think that right holders should be concerned with the fact that the more the consumers will opt for services on demand, the less scope will there be in the future for the traditional private copy levy system. And therefore it is a challenge, a fundamental challenge, to guarantee the right holders' rights and interests in this new digital environment. And one of the ways, I'm not saying given that it is the only way, but one of the ways that was put forward was to experience licensing in the online services. And therefore, how can we better protect the interests of the right holders in these new business models that are emerging, that are basically services that are based on licenses? Having said that, I do recognize, and my report also expresses that idea, that there is a huge imbalance of bargaining power between the right holders and the producers or the businesses that use that content. And therefore, there is a need to guarantee that this relationship, this contractual relationship, is much more balanced. Because there are public interests at stake. It's not just a question of a pure relationship between one private and another private. It is absolutely necessary to guarantee creativity and to guarantee that there is innovation in our creation, that the right holders should be protected in the contractual relationship with the business. Having said that, of course, that cannot just come from any kind of system of private copy levies. I think we need to be more creative, more imaginative, and trying to address issues of corporate law or labor law that will have to be called upon to be present in this rebalancing of the bargaining relationship between right holders and business. Of course, I do understand that sometimes the right holders have some difficulties in accepting that we are entering a brand new world, because it's an uncertain world. Even the business models are not stabilized, and that's one of the critical issues. I mean, usually the industry says that the private copy levies are preventing from the development of new business models. To be honest, I did not find in the existing system any unsurmountable obstacle to the development of new online businesses in this area. But having said that, I do recognize that the relationship between right holders and business will be totally different in some years to come. And I believe it is in the interest of right holders to prepare for this new environment in order to safeguard their legitimate interests and rights, to be remunerated, fairly remunerated for their creative work. And at the end of the line, it is also in the interest of the business that the right holders feel comfortable with these new systems. Because if the right holders do not create, if the creators do not produce the content, the business will have no business at all.
Thank you very much. You raise a very interesting point with regard to the balance that has to be found in the new business models. With regards authors, you know, collective management societies are in the beginning of this dilemma since 200 years ago. They were organized almost as labor organizations in order to give authors that bargaining power that they didn't have by themselves. But this function of collective management society sometimes I think it has not been understood in its all complexity by the European Commission. So the vision that you are raising now, I think it is very positive since it will help authors in this new scenario. So do you think that the European Commission, now that there is a new collective management directive on the way, has understand better the role of collective management societies?
Well, at least one can say that the new directive on collective management societies is a step forward in the right direction. There is a recognition for the need for such societies to be taken as full players in this bargaining exercise. And therefore the fact that exists now European legislation reinforces the role of each collective management society at national level. I don't ignore the fact that there are specificities from member state to member state, but there is now a common level playing field. And it is possible to build on that common level playing field a better capacity to interfere in the bargaining process. I believe that there are specificities according also to sectors. Authors, performers, artists, players. There are different problems in all these categories. But of course, if they unite, they will be in a much better position to bargain with the business, because today the business dictates the rule of the game. And it is in the mutual interest that they find an equilibrium, a break-even point where the solutions that might be found will be win-win solutions that guarantee the rights of the creators, artists, performers, and at the same time solutions that also allow the development of the new business models.
Okay, and in this complex scenario that we have, Spain has moved step on one side and has modified completely the Spanish legislation on private copying. In your recommendations, you propose as a way to resolve the internal market problem existing today with private copying to fully harmonize the levies, for example, including the tariffs, to introduce an obligation to display the levy to the final customer in order to benefit all parties involved, or to create a national authority that will supervise the tariff settings. Spain it's going in another direction in this moment, and I would like to ask you, to pose you a tricky question. If you had to advise the Spanish government in this moment with regard the reform of the intellectual property law they are undertaking with regard to private copying, what would you tell them? Would you?
Well, before addressing this very specific Spanish case, let me just say that those alternatives that you have put forward are theoretical alternatives. In fact, for instance, in my personal
examples
opinion,
that I wanted to
it would be extremely difficult, if not impossible, to harmonize the tariffs, because that would collide with the principle of subsidiarity, and there are different historical and cultural traditions. So to a large extent, I've been more humble, and I've said that we could improve the system by establishing some rules, some common rules, for instance, on the definition of harm as a lost profit by the right holders due to the private copy, or the possibility of having standard procedures to determine the levies that are applied to specific devices within a certain time frame. That is extremely important to guarantee that when a new device is put into the market, it does not wait too much time before it can be collected, levied, and therefore be of interest to the right holders. Having said that, now concerning Spain. Yes, indeed, the Spanish case is a very specific one, because as far as I know, there is only another country in Europe which follows a similar approach, which is Norway, in spite of the fact that there is a different framework. And I know that the Spanish solution is very controversial in Spain. And there are several court cases, as far as I know, and several complaints that have been presented to the European Commission. And as far as I am informed, the Commission is studying those complaints, is dialoguing with the Spanish authorities in order to assess what are the points that might be in collision with the European law. Now we have 1 full year of application of the new law. We'll have to look very carefully to the figures, especially as far as the impact in the market, the price of the devices, for instance, or the deprivation of income from the right holders, which apparently is an evident case. Those are questions of political legislation, political options. Of course, there is a debate there, and I think it is important to follow that debate. There is one specific aspect of a legal nature, more legal nature, that to me raises several doubts. The directive of 2001 and the jurisprudence of the European Court of Justice has made clear that the logic of the private copy levy system is to establish a link between the benefiter of the copy, the private end user, that needs to compensate for the harm caused by the private copy to the right holder. So the jurisprudence and the legislation establish a direct link between the end users, the private end users for private use, and the right holder, and the damage, the harm caused to the right holder. Of course, in a system like the current Spanish system, that link does not exist, and that will definitely raise an important legal question. We'll have to wait to see how the Commission assesses that problem, and if the Commission decides to proceed to the court, to the European Court of Justice or not, or, which is always another possibility, the Spanish system changes.
Okay, thank you very much.
Thank you.